It is more important to outthink your enemy than to outfight him. Victory comes from finding opportunities in problems. Sun Tzu. Today, I'm going to be sharing my views on what I perceive to be a social media constitutional crisis in the United States. While this channel's focus is primarily on pointing out misandry and related commentary, one might ask, how is this relevant? It's actually pretty simple. The main groups that oppose Americans' First Amendment constitutional rights to free speech are feminism and the social justice movement. As many other content creators have amply demonstrated throughout the years, when these groups are called out for their indefensible hypocrisies, rather than admit their faults, they resort to reframing opposition to their bigotry as hate speech or harassment. Then this is followed shortly thereafter by calls for censorship, either through social media banning or through the social media platform removing the opposing viewpoint. Because others have described the many instances of this in detail already, I won't be delving into it here. The three companies that control the majority of online social interactions are Google, through YouTube, Facebook, and Twitter. Their customers are both individuals who sign up for these services and the companies who pay for the marketing intelligence and advertising access to these individuals. Further, individual users on Google's and Facebook's platforms can create public and private online communities based around common interests or backgrounds. Because these platforms serve as conduits for meeting people, they're the online version of the public square. However, instead of being limited to their local community, these online public squares can potentially reach the entire world. Why is this important? By now, it should be common knowledge that these three social media platforms openly discriminate against those who speak out against feminist and social justice hypocrisy. As an example, YouTube does this by barring content creators who disagree with feminism and social justice from earning ad revenues for their videos. In addition, they openly admit to manipulating search results in an effort to censor these voices and to conceal the growing opposition to both feminism and social justice from their viewers. Many content creators and subscribers have expressed concerns that YouTube has removed subscribers from channels and has stopped notifying them of these content creators' new videos, even if they've signed up to be notified. Even worse, YouTube has restricted videos from being shared and in some cases, closed channels down entirely. The majority of channels hit by these social justice witch hunts did nothing more than explain their disagreement with social justice and feminist bigotry. As everyone knows, many content creators rely on their YouTube revenue to pay their bills. Thus, these witch hunts have had real-world impacts on the victims of YouTube's discrimination. Even worse, because these social justice witch hunts have been highly publicized, they've had major chilling effects on free speech on their platforms. While many people have claimed that since these are private companies, there's no recourse for any of their victims, I disagree. I perceive a two-pronged approach to bringing accountability to this campaign of social justice censorship. The first has already been adopted. Discrimination breeds competition. Before these platforms abandoned their free speech ideals, there was no reason to consider other social media platforms. However, the social justice witch hunts have created a demand for alternative social media platforms committed to free speech and are drawing in new users daily. These are Bitchute, VidMe, Minds, and Gab, to name but a few. Secondly, and this is the solution I favor, sue them into the Stone Ages. Allow me to explain. On June 19, 2017, the United States Supreme Court ruled on a free speech case out of North Carolina, Packingham versus North Carolina. Packingham was a convicted sex offender who was barred by state law from using social media. The United States Supreme Court held that North Carolina's law restricting his access to social media violates his First Amendment constitutional right to free speech. In their unanimous ruling delivered by Justice Kennedy, stated in pertinent part, a fundamental principle of the First Amendment is that all persons have access to places where they can speak and listen, and then, after reflection, speak and listen once more. The court has sought to protect the right to speak in this spatial context. A basic rule, for example, is that a street or a park is a quintessential forum for the exercise of First Amendment rights. Even in the modern era, these places are still essential venues for public gatherings to celebrate some views, to protest others, or to simply learn and inquire. While in the past there may have been difficulty in identifying the most important places, in a spatial sense, for the exchange of views, today the answer is clear. It is cyberspace, and the vast democratic forums of the internet in general, and social media in particular. 7 in 10 adults use at least one internet social networking service. One of the most popular of these sites is Facebook, the site used by the petitioner leading to his conviction in this case. According to sources cited to the court in this case, Facebook has 1.79 billion active users. This is about 3 times the population of North America. Social media offers a relatively unlimited, low-cost capacity for communication of all kinds. On Facebook, for example, users can debate religion and politics with their friends or neighbors, or even share vacation photos. On LinkedIn, users can look for work, advertise for employees, or review tips on entrepreneurship. And on Twitter, users can petition their elected representatives and otherwise engage them in a direct manner. Indeed, governors from all 50 states and almost every member of Congress have set up accounts for this purpose. In short, social media users employ these websites to engage in a wide variety of protected First Amendment activity on topics as diverse as human thought. The nature of a revolution in thought can be that, in its early stages, even its participants may be unaware of it. And when the awareness comes, they may still be unable to know or foresee where its changes lead. So too here. While we now may be coming to the realization that the cyber age is a revolution of historic proportions, we cannot appreciate yet its full dimensions and vast potential to alter how we think, express ourselves, and define who we want to be. This case is one of the first this court has taken to address the relationship between the First Amendment and the modern internet. As a result, the court must exercise extreme caution before suggesting the First Amendment provides scant protection for access to vast networks in that medium. Now, simply put, this means that in June 2017, the Supreme Court unanimously ruled that the First Amendment constitutional right to free speech extends to social media platforms. For those that don't see the connection, allow me to further break it down. The United States federal courts have previously held that hate speech is a form of protected speech under the First Amendment. When taken into combination with the Packingham ruling, a very credible case can be made that social media platforms who censor, demonetize, suspend, or ban their users for hate speech-related reasons are in violation of their civil rights because these social media companies are barring them from exercising their First Amendment constitutional rights to free speech. Even more troubling is that the individuals that use these platforms aren't just users, they're also customers. More importantly, in real terms, those customers who are content creators are also small business owners. They've spent large investments of time and money branding their media personality and video content as part of their small business strategy. Many use multiple social media platforms and sometimes even have websites promoting their brand. When these business ventures are discriminated against, they're not only barred from exercising their First Amendment rights, but they're further damaged in real terms because they're prevented from marketing and selling their brands to large groups of potential customers and fans. These civil rights violations directly lead to lost revenue and brand reputation, which when taken together are often fatal to these media personalities' online ventures. So not only do these civil rights violations interfere with people's ability to exercise their personal civil rights to free speech, they also interfere with business civil rights to promote and profit from their business ventures. With this in mind, I'm not the only one who realizes the injustices being committed by these social media giants. On September 14, 2017, Gab filed a lawsuit against Google for barring its application from the Google Play Store, accusing it of antitrust activities. However, shortly after filing and publicizing its lawsuit, on October 22, 2017, Gab voluntarily dismissed it. Their reason is because Google offered and encouraged Gab to resubmit their app to the Android store to avoid further litigation. Given Google's history of dragging out legal actions against it, their desire for an early settlement makes it clear that they're terrified of what might be discovered during an extended court proceeding or trial. It's also an admission that social media giants are paper tigers. I'm not the only one with this view. On October 23, 2017, Prager U filed a lawsuit against Google, in part because of Google's violations of Prager U's freedom of speech. While this lawsuit will be interesting to watch, I don't believe it goes far enough. It's my view, based on both the Supreme Court ruling in Packingham and its prior rulings protecting hate speech, that every individual, content creator, and media personality who's been censored, suspended, banned, or demonetized on any social media platform should get together and file a class action lawsuit in the U.S. federal court against Twitter, Facebook, Alphabet, and its subsidiaries, Google and YouTube. The beauty of filing a lawsuit in the U.S. federal court is that the filers would be entitled to punitive damages. What does this mean? In layman terms, punitive damages are fees awarded to lawsuit filers who prevail in court as a deterrent to the defendants and others who may want to engage in similar civil rights violations. Alphabet, Facebook, and Twitter together earned approximately $30 billion in net profits for 2016 alone. Thus, when a class action lawsuit is filed, the class would be justified in asking for damages such as lost revenue, lost reputation, damage to their media brands, and any emotional distress. In addition, they may be entitled to recovering their attorney fees. And finally, I believe that they should ask for a minimum of $30 billion in punitive damages for these social media giants' well-documented history of violating their users' First Amendment free speech rights. This will send a message that when social media companies violate the U.S. Constitution, there's real consequences. Now, it's clear that no social media user or content creator has the money to fund such a lawsuit. However, I've thought about that also. Sargon of Akkad by himself has over 700,000 subscribers. Dave Cullen has over 200,000 subscribers. Black Pigeon Speaks has over 260,000 subscribers. Stephen Molyneux has over 680,000 subscribers. Rebel Media has over 850,000 subscribers. Laura Southern has over 370,000 subscribers. And Blair White has over 350,000 subscribers. And then, of course, PewDiePie has over 50 million subscribers. If just these content creators alone raised 50 cents from each of their subscribers, they would have a $20 million nest egg to fund this class action. It would be more than enough to take this case to the U.S. Supreme Court with a very good chance of winning. Further, because it would be a class action, many other content creators could join in and help with additional fundraising, as this type of lawsuit would benefit everyone. Now, I know the question on many people's minds is, DDJ, I'm not a U.S. citizen and I don't live in the United States. Am I barred from pursuing legal action? While I'm not an attorney, and nothing I say on this video should be misconstrued as legal advice, my personal opinion is that I don't believe so. While many content creators are outside the United States, it's been established that even illegal aliens have constitutional rights under the U.S. Constitution. Further, since these social media companies were founded on U.S. soil and maintain their base of operations here, people who are not U.S. citizens could be included in the class action, especially content creators and media personalities because they do business on U.S. soil by virtue of receiving funding from U.S. citizens. In addition, can you imagine the media firestorm that would occur just from filing such a lawsuit? It would have far-reaching consequences that even the mainstream media couldn't ignore. It would potentially change the landscape of online social media forever. Filing this kind of class action would give voice to the voiceless and hold feminists and social media bigots accountable for violating one of the most sacred foundations of the United States Constitution and our country, our right to a freedom of speech. Our U.S. constitutional right to freedom of speech will only survive as long as we're willing to defend it. To my fellow content creators and social media users who've been targeted by social media giants, I ask this: are you willing to stand together and fight for your right to create content and to speak freely online in the public square of social media and defend that right from feminist and social justice discrimination? Given how little resistance feminists and social justice warriors have received from the online content creation community so far, I'm skeptical of my colleagues' willingness to take this necessary step to protect their media brands. However, in the end, time will tell. I'm DDJ, and this has been your first dose of Misandry Today.